All rise. The Honorable DeAndre Fields is now presiding. Thank you. You may be seated. Welcome to our third module, and welcome to Chapter 7. Now, you're probably saying, look at Professor Fields. What's with the robe? What's going on? Well, in case you haven't guessed it, which I know you have, this chapter is going to examine the courts and the judiciary. And what I'm hoping to convey, and it is my fervent belief that as we continue to take this journey in discovering and discussing the criminal justice system, that as we are transitioning into the courts, which is the second primary component of the criminal justice system, that you will review and see that there are key figures that exist in a court setting. Now, I hope that none of you have ever gone to court, and some of you may have visited as part of a field trip. Maybe you were in some civic or academic program where it gave you access to a court. Some of you might have friends or loved ones or family members who are attorneys, maybe even judges. If you've never gone to court, understand that things are done very orderly. And during this chapter, and especially in the coming chapters, I will certainly harken back and talk about my court experience. Not too much, because I believe in moving things along. But just as you saw that introduction, all rise, the Honorable DeAndre Fields is now presiding. And then as judge, I said, please be seated. You will rise. You can sit there and be like, whatever, I'm not rising for this guy. I'm not rising for this woman. And you're probably going to get checked by a deputy. And you don't want that. Judges command respect. And what I'm hoping to show as we talk about not just the courts, but the judiciary itself, I'm hoping to convey to you how the judge is arguably one of the most powerful individuals in all of the criminal justice system. And judges command a level of respect like no one else. So let's go ahead and jump in. It's important to understand the court process, correct? And with the court process, if a case occurs, what can happen is something called a judicial review. This is where a higher court has the ability to review decisions of lower courts. In fact, having judicial review gives the Supreme Court authority over constitutionality of law. Now, we'll talk about the Supreme Court in just a moment, right? But to go back to what we talked about, I believe it was in chapter 2, correct? I believe it was chapter 2, or may have actually been chapter 3. My apologies. In chapter 3, I said that there are 3 co-equal branches of government. What are they? The executive branch, which is the president of the United States, and the vice president of the United States. Then we have the legislative branch, which is Congress, the Senate, and the House of Representatives. And then we have the judicial branch, which is the Supreme Court. And this is where we are now. So because we have this separation of power, judges are free to make decisions without political influence. Now, it may not always be the case, and we'll get a little bit into that. Not too much, because we're not getting in the weeds too much. But understand that there are a separation of governmental branches, and they are co-equal branches of government. So judges typically decide cases based on, one, the strict interpretation of the Constitution. If you want someone that is going to be able to strictly interpret the Constitution like no other, you better go befriend and talk to a judge. Also, they have the ability to interpret the document within the context of historical, societal, and technological events. The Constitution was written back in 1776. Right now, we're in 2025. So do the math. We're talking nearly 250 years, give or take. Yeah. So essentially what we're looking at is that time has changed, society has changed, technological advances have changed, and that's why when it comes to interpreting the Constitution and law, judges have to stay well versed in it. Plus they have law clerks and they have people who help them. And then, of course, there's the idea and the notion of precedent. Precedent is where an earlier event or action that is regarded as an example or guide to be considered in subsequent similar circumstances. Precedent would say that, hey, if I know that, um, name your favorite sports team. Let's say you like the NFL, and mine is the Baltimore Ravens. I'm just throwing them out there. Well, if we know, and you're the Cincinnati Bengals playing the Baltimore Ravens, and you know that precedent tells us that it's 3rd and 2, either Lamar Jackson is going to run this football or Derrick Henry, the running back, is going to run the football. We know that they do this 80 to 90% of the time. Well, that's precedent we can go on, right? We have a guide based on similar circumstances and situations. And then, of course, it's 3rd and 2, and the Ravens pass the ball, and it goes for a touchdown, and I'm cheering. But that's precedent, right? And I'm bringing football into this. But that's precedent. It looks at an earlier event or action, and then judges can use that as a guide to determine how to sentence somebody based on that earlier action. So when looking at the court process, there's another thing called judicial activism. This is where there's a variation from the clear meaning of the text, and it allows for broad interpretation. Now, precedent was established in some key cases. For example, you have Plessy v. Ferguson. Plessy v. Ferguson had the doctrine separate but equal, right? So in essence, it was considered legalized racial segregation. In fact, under Plessy v. Ferguson, blacks and whites had separate facilities, and it was considered equal. Now, we know it wasn't equal because you couldn't go to the white water fountain and drink. If you did, they were probably going to knock your teeth out, and then they were going to tear down the water fountain and, replace a new one, right? There's also the idea and the notion that segregation didn't violate the 14th Amendment. Now, we talked about the 14th Amendment in the previous chapter when we looked at police and the rule of law. What was the 14th Amendment? The 14th Amendment dealt with our due process rights, correct? So because it dealt with our due process rights, if the feeling and idea is that separate but equal does not violate that amendment, even though things are separate, the feeling is everybody's still equal. Now, Plessy v. Ferguson was in existence from 1896 to 1954. So just shy of about close to almost 60 years, 58 years or so. What ended up happening was you had Brown versus the Board of Education, and that was the landmark decision where judges said that separate but equal is wrong, and it became dead. And that Brown versus the Board of Education case allowed for people of color, black people, to go to school. It banned segregation in public schools. It's a landmark case that we feel even to this day. So let's talk about our federal and state court system, right? We know with the federal courts, they operate under a dual court system. So it's a separate system for federal and state levels. Federal law will always trump state law. So my argument is that if you get in trouble and they say the feds are coming after you, watch out. I repeat, watch out, because with the feds, anything federal is going to be very, very, very complex and is probably going to have deep, deep penalties. You always, all day, every day, want to deal with the state. Anytime the feds are coming in, it's going to be an issue. And so with that being said, it's very possible under a writ of certiorari that the federal courts can get involved in a case, but then they decide to send it to a lower court, or they decide to send it to an appellate court rather for review. So federal courts can say, well, before we finally take up this case or make a ruling in this case, we want an appellate court or a lower court to review it and make a decision. And then we may support this or uphold it, or we may overturn it. Now, in terms of federal courts, understand the jurisdiction refers to a court's authority to hear certain types of cases. Federal courts, rather, they won't hear cases involving state laws unless the laws conflict or the issue is appealed as a constitutional matter. So You can't take a state case per se and have it heard in federal court. It doesn't work that way. But the jurisdiction will also vary. It also varies based on the type of case in action. Now, understand that there's some specialized jurisdictions in any court, family court, juvenile, divorce, criminal. You're not going to have a whole lot of specialized federal courts. You will not have a federal juvenile court. You will not have a federal divorce court. You will not have a federal family court, but you probably will have a federal criminal and civil court because the feds are all about going after the big time spender, the big time criminal, rather, the big time offender. So understand that within federal courts, they really only operate under real two kind of caveats: criminal and civil, possibly bankruptcy, but certainly criminal and civil. But with state courts, you're going to have a whole plethora of specialized courts. Now, the United States Supreme Court, as I shared a few moments ago, is the highest court in the federal system. It's also the highest court in our country. It's the highest court in the land. And it was established by the Judiciary Act of 1789. So remember, we were birthed as a nation in 1776. We did not have a Supreme Court until 1789. Now, the Supreme Court consists of one Chief Justice and 8 Associate Justices. So unless you're the Chief Justice, everyone else is referred to as an Associate Justice, regardless of how long you've served on the bench or not. Now, just a couple of superlatives. First Chief Justice was John Marshall. The first female justice was Sandra Day O'Connor. It was 1982. First black justice was Thurgood Marshall. Each appointment is by the president, who nominates a cabinet for approval, or candidate rather, for approval by Congress. Understand that when the president nominates somebody, it is ultimately up to Congress to hear the nomination and provide the confirmation. That is not always the case because there was, some will argue it's highway robbery. Others will say it was a brilliant move. But basically, a former president, which I'll get to in a second, appointed which would have been his third Supreme Court justice in 8 years of serving as the presidency, and he was literally blocked by one man. He was stonewalled by one man who said, "We're not doing it. We're not taking the vote." And that Supreme Court seat stayed vacant for about a year and a few months. But the reason why that's important is because, look, when it comes to the Supreme Court, these are lifetime appointments. Look at the salary. $286,700 for the Chief Justice, $274,200 for the Associate Justices. You worked 5 years as a Supreme Court Justice, and you made over $1 million in 5 years. And that doesn't include endorsements, other perks. I mean, you're living the high life making that type of salary. And you are a public figure because people are going to know who you are. But what I want you to know, too, is that there are a great deal of discretion in cases that the Supreme Court hears. They don't take every case, but they do have a great deal of discretion. Now, I want you to see right here, and this is why it's important for you to pay attention to politics to an extent. Look right here and look at when these individuals were appointed. Look right here. I mean, Justice Stephen Breyer, he finally retired. He was 83 years old. He was appointed by President Bill Clinton in 1994. But look at these appointees. Look at Justice Clarence Thomas. He was appointed in 1991 by President George H.W. Bush. Justice Clarence Thomas is still on the bench. 1991, folks. Now listen, you might be like, I wonder how old Professor Fields is. Let me put it like this. When Justice Clarence Thomas, who, by the way, little known fact, he took the seat that was held by Justice Thurgood Marshall. So we've only had 2 black men who have been on the Supreme Court in our 200 plus years of being a country. He took the seat that was vacated by Justice Thurgood Marshall after his passing. With that being said, Justice Clarence Thomas was appointed on the bench in 1991. Do you know I was a kid when that happened? Yes, I was a kid when he was appointed on the bench. He is going nowhere. And why would he? 70 something thousand dollars a year, and he's been doing that since 1991, and we're in 2025. Yeah, he's definitely he's not going anywhere. But as you can see, quite a few of these appointees were by President Trump. You had some holdovers from President George W. Bush. He had a couple back in 2005 and 6. But the oldest holdover is Justice Clarence Thomas, who will go nowhere because he's been there since 1991. And here's our current Supreme Court justices now. And they do it from the Chief Justice is always sitting right smack dab in the middle. On his right and then on his left are the most senior appointees. So because we are rapidly moving, Justice Clarence Thomas, again, since 1991, has been on the bench. Justice Samuel Alito since, I believe, 2005. He's next to him. And then on the ends, you have Justice Sonia Sotomayor and Justice Elena Kagan. Those were both appointed by President Obama back in 2008, 9-ish. And then everyone in the back are President Trump appointees. And then the sister, Justice Ketanji Brown Jackson, she was appointed by President Biden. So as you see, 1 Chief Justice and 8 Associate Justices. And let me tell you this before I move on. Is this thing political? We'll come back to that in a moment. So in terms of state courts, the structures vary, but it all depends on what state you're in. So state courts have a state Supreme Court. The state Supreme Court varies in terms of number of justices. So Florida has 7 justices, Georgia has 9, Alabama has 9. You have to look at your state Supreme Court and see how many justices there are. The term is for 6 years. Is it politically motivated? Just like the Supreme Court, it is. Because as you can see, in some states, depending on who's in leadership, whether it's a Republican or a Democrat, they appoint the judges. In other states, you run for election and the people decide. But either way, it is still very much politically motivated and politically charged. So going back to state courts, again, they are the intermediate courts between the trial courts and the Supreme Court. They do make determinations on all filed cases, and in many cases are filed pro se, which means a person can't afford representation, so they're doing it, by themselves. Now, pro bono is for free, but pro se is just without legal representation. Just understand that when we get into the chapter, I believe it's the next chapter talking about lawyers, you don't want to be filing briefs and motions and, filing documents on cases. You don't want to be doing that unless you absolutely know what you're doing. You absolutely need the assistance of an attorney, even though attorneys can cost a lot. Because when you go in front of a judge is not going to say, "Oh, I'm so sorry, you didn't know what you were doing, I give you a pass." No, the judge is going to hold you just to the same standard as they would hold an attorney to their standard. So again, with state courts, think about trial courts. Trial courts hear criminal and civil cases. They operate under rules of evidence. Sometimes they have limited jurisdiction. So you might have a magistrate court, or you may have a municipal or city or county court. You just have to see what courts are in your discipline. Because for me, it took a little bit of an adjustment coming to Georgia courts compared to Florida courts. To me, everything was seamless and it was easy. But I just said that because I had worked in Florida courts for the better part of a decade, and I was just used to how things ran. With that being said, understand that every court is going to be different. How courts run in Florida are not how courts run in Georgia, and vice versa. So every court is going to be different, and it's your responsibility to know what the court's differences are and what their responsibilities that they bestow upon you, what they are as well. So when looking at the differences between federal and state courts, obviously there's major differences. For example, state courts, they don't have the same jurisdictional power as the federal courts. Also understand that when looking at federal courts Felony prosecutions must be initiated by indictment and are used in cases involving more serious crimes. But in a state court, it'll begin with either an information or a complaint, right? So an indictment at the federal level, that's the result of a grand jury that comes together, hears evidence, decides whether a person should be charged with an offense, and is typically presented by a grand jury. As I shared with you all a few chapters ago in earlier lectures, I said right now there is an infamous man in New York City that is on trial, and he might be in the trial of his life. Of course, it's anybody's guess as to what's going to happen, and ultimately will his conviction be upheld via, would the conviction be upheld? Having said that, there was a grand jury that heard evidence and decided whether to file charges against said hip-hop mogul. That was because of an indictment. On the other hand, the judge or the prosecution likely had enough information at that time to file what's called an information. However, an information is, obviously based on an assumption with whatever police report or evidence that the law enforcement officer has. But an indictment is where your peers have heard enough evidence and they're like, no, this is an individual that needs to be incarcerated because, they are a danger to our society. That's why we as a collective group agree to file charges. That's what the indictment means. Now, in terms of court congestion and consequences, justice delayed is justice denied. In other words, delays can create positive and negative consequences for involved parties. We know that some people like to delay, because if they delay long enough, they won't have to, in their minds, pay the piper for what happened. But we know eventually justice will be served. Sometimes it can take 2 years, 3 years, 5 years, 10 years, hopefully not more than that, but it can happen. So justice delayed is justice denied because most people that are wrong want justice, and they usually want it very quickly and swiftly. But why did we have some delays? Well, as you can see right here, COVID-19 caused a lot of issues. That's something that I would talk about in my in-person class, where I would show some clips, and even as far back as maybe a year ago, a lot of cases were still behind because it was just a backlog, right? So you see that as a common theme, and we know that COVID-19 caused immense stressors, not just in the lives of Americans, but of course on the resources that we use, such as our great judiciary. A lot of court cases could not be heard, and people were languishing in jail because nobody knew what to do and what to expect. So looking at the judiciary, let's talk about why I'm wearing this robe, right? If I'm operating in the role of judge, please understand and know that a responsible functioning of a courtroom is done at the behest of the judge. Judges determine appropriate conduct. They also determine what evidence may be introduced and even understanding the correct procedures. Now, what I do want you to focus on and know is that judges play a very pivotal role in the courtroom. They are arguably the most important character or official in that courtroom. Having said that, controversy may still exist because in some jurisdictions, prosecutors wield immense power. So even though it's believed that the judge is the person who has the most power, it's not necessarily the judge. A lot of times it's the prosecutor, the state attorney. So having said that, when we look at the judiciary, you got to say, okay, well, what qualifications do you have to have in order to be a judge? First of all, you have to be living in whatever state that you want to become a judge, right? You can't just be like, I live in Ohio, but I do commute into Tennessee because I know those are border states, or Michigan, but I want to be a judge in Michigan even though I technically live in Ohio. You can't do that, right? Some appoint judges to the bench while others hold elections. In other words, sometimes the governor may appoint a judge to the bench. In other instances, an election may be held to give the person an opportunity to run to get people's vote to become judge. And you can see what it is in certain states like Georgia, Florida, Alabama. Those are the states that chose because of their southern closeness and proximity. You have to have a license to practice law. You have to practice for at least 7 years, be a member of the state bar, and the age range is usually 25 to 70. Some states do require the judge to retire at 70. Now, again, some people would argue, well, that's not fair. If a judge wants to be a judge until they're 80, 82, 83, as you saw, I'm not going to go back, but you saw people like Clarence Thomas, and that picture was taken several years ago because I told you President Biden appointed Justice Ketanji Brown Jackson. He did that early on in his career as president. So someone like Justice Clarence Thomas, has got to be close to 80 years old, maybe, or in that ballpark. So he's still operating, even though some states require the judge to retire at 70. Now let's talk about women in the judiciary, right? So in the late 1800s, women have had to fight not only to attend law school, but they had to fight to be admitted to the bar, and they had to fight to serve as a judge. Now, as of June 2022, and we can even take that into modern times, so June 2025, because no Supreme Court justice has resigned, there have been 116 justices who have served the Supreme Court. How many have been women? 6. 6 were women. The names are Justice Sandra Day O'Connor, Ruth Bader Ginsburg, Sonia Sotomayor, Elena Kagan, Amy Coney Barrett, and last but not least, Ketanji Brown Jackson. That's the order. That's it. Only 6 Supreme Court justices have been women. Period. So it's one of those things that is so problematic, and I know a lot of people don't like to tear this whole talk about diversity, but how have we only had 6 Supreme Court justices that have served on the bench since the inception of our country back in 1776? It's mind-blowing and it's jarring, to say the least. Racial diversity in the judiciary also becomes an issue because think about Macon Bowling Allen, first black attorney in the United States in 1844. The first black judge to serve at the federal level was appointed by President Truman back in 1945. So you're talking like post World War II. His name was Irvin Mollison. Of course, I told you Justice Thurgood Marshall was the first black Supreme Court justice. And then, of course, he was preceded by Clarence Thomas. He occupies the same seat that Justice Thurgood Marshall took. Like, he took his spot. So you had Thurgood Marshall, served on the bench for like 40-something years, passed away. Clarence Thomas has been there, and he's been there since 1991. So there you go. So 2 black men have held the same Supreme Court justice seat. And then, of course, we have Justice Ketanji Brown Jackson. She got in 2022 under President Biden. Again, looking at the racial diversity, understand in cases like Hernandez v. Texas, Mexican Americans and racial groups have equal protection under the 14th Amendment. The 14th Amendment provides you an opportunity for due process. Now, we've had some gains, but we haven't had enough. For example, you had Alberto Gonzalez. He was the first Hispanic Attorney General, appointed in 2005 under President George H.W. Bush. You had Justice Sonia Sotomayor. She was appointed in 2009, first Hispanic Associate Justice. Listen, diversity improves the quality of life for everyone, okay? I mean, I know you don't need me to tell you this, but it's okay to have people from different backgrounds in your circle. Don't just surround yourself with like-minded people. That's not to say you're compromising your morals, your values, or your integrity. What I'm saying is have people around you that have some differences and that have come from some different backgrounds, because they can educate you on stuff that you didn't know or things that you don't know as it relates to other backgrounds. And that's why diverse judge appointments are helpful. We want black judges. We want brown judges. We want judges who are from Asia or from India or from European countries, if they are well versed in the law. We want Diversity. Okay, diverse judge appointments improve the quality of life for everyone and the quality of justice for everyone as well. So the apolitical nature of the United States Supreme Court is questionable. Presidents can appoint justices to change conservative or liberal-leaning court decisions. In 1937, President Franklin Delano Roosevelt attempted to increase the number of justices to 15. So remember, there's currently there's again 9 Supreme Court justices, right? He wanted to go from 9 to 15. He was stymied by the Senate, who saw it as something called court packing. And again, President Franklin Delano Roosevelt, you're talking 1937. We were also in the midst of about to go into World War II, but that was about the closest we've come to having what's called court packing. And it's a very hot button topic on certain political circles. In fact, here you go. Court packing is this hot topic in political circles and a rallying cry around both parties. It's centered on the belief that the Supreme Court needs to be balanced by increasing the total number of justices from 9 to at least 12, or if not, 15. Because currently, again, just talking politically, just from the perspective of justices, right now, 6 of the justices are quote unquote conservative leaning, right? So they would typically, under a conservative leaning approach, make rulings based on conservative values, whereas only 3 justices are liberal leaning, right, or have a liberal background. So some people are saying if you go from 9 to, let's say, 12, maybe 3 more of those justices can be more liberal leaning. But what if they were more conservative leaning? Now you went from 6 to 9 who are on the same page and only 3 who are not. So it's controversial. I don't have the right answer or right solution, but I can tell you that, many people feel like, if we want to make changes in this country, we don't have to worry about putting on more justices, putting on more, Supreme Court justices. We have to start the change at the local level. If we can't start it there, then it doesn't matter what happens in Washington, D.C., because nothing will change, and that includes judges. As you see from this great picture, you got President Obama and President, Trump waving at each other. Again, it was kind of one of the last times where you had a cordial, quote-unquote, changing of the guard. Although you did have it when President Biden lost the election, he did invite President Trump, but there was no, cordial demeanor when President Trump lost to President Biden. So typically, presidents are supposed to be cordial with one another. The reason why I include this is because, again, President Donald Trump had the rare opportunity to nominate 3 justices, and that was in his first term, right? Could you imagine what's going to happen in the second term if 2 people retire, or even 3? He could have 6 Supreme Court justices appointed under his watch that will literally shape the bench for the next 30 plus years. Think about your age as a college student, or if you're an adult watching this channel, I don't know. If you're a 18, 19, 20-year-old college student, you might be looking at a potential new Supreme Court justice coming up within the next year or so that'll be on the bench from now, the time you're 18, 19, 20, all the way up until you're somewhere in the 40, 50-year-old range. I mean, we're talking 20 plus, 30 plus years of service as an associate justice. And why would you leave? You make so much money, right? Of course, in 2020, a few months after the passing of Justice Ruth Bader Ginsburg, Amy Coney Barrett became the first justice confirmed with no support from the opposite party. She passed the confirmation by 1 week before the 2020 election. And so, do politics play a key role? Absolutely. I know we might not like having politics in the judiciary, but the truth of the matter is we do. We have it in the judiciary because if presidents are political and they're appointing people who have the same political ideals that they do, well, then you're not going to have any diversity per se, because either you're going to get leaders who are of a different race, ethnicity, etc., appointing people that most closely line up with their race, ethnicity, etc., or you're going to get the exact opposite. Politics play a pivotal role in judges securing seats on the bench. So the last thing is I want to just kind of segue into problem-solving courts. Since we talked about federal courts and we talked about state courts, I do want to segue and talk about what's called problem-solving courts, right? And what are problem-solving courts? They're specialized courts designed for specific offenses and offenders. Typically, the difference between a criminal court and a problem-solving court is that a problem-solving court is going to focus on first-time offenders, nonviolent people, some felons, but not often. The outcome focuses on reduced recidivism and rehabilitation. What you'll hear me say again later on in the semester is rehabilitation is another fancy word for being sick and getting treatment for sickness. That treatment for the sickness is that an individual has committed a crime, they have a specialized or specific crime, and so therefore we need to treat them, we need to rehabilitate them. Their crime is their sickness. So one of the most notable problem-solving courts are drug courts. Drug courts came about in 1989. What was going on in 1980 in places like Miami? You had the cocaine cowboys. You had drugs just flowing down the street, right? So they created a drug court because what they found was that people were getting hammered with lengthy prison sentences, even though they absolutely needed substance abuse treatment. And that's where drug courts became arguably the most common form of problem-solving courts in the United States. Again, the treatment is very much treatment-oriented, but punishments and sanctions do exist. You're not going to walk into the courtroom having failed 5 drug screens and expect the judge to be like, all right, man, you good. We'll see you next week. Or like those two guys are doing, they're shaking hands. Absolutely not. The first drug screen, you're probably going to get a warning. The second drug screen, you might have to do a sanction. But that third, fourth, fifth drug screen, you're going to jail. And eventually, judge is going to say, you're not taking this program seriously. We're just going to go ahead and kick you out. We have veterans treatment courts. They began in 2008. Veterans treatment courts are relatively newer. I mean, it's still been around for 17 years, but they assist returning servicemen and servicewomen with mental health disorders or other criminal incidents who face criminal prostitution. Back in Florida, we had an outstanding judge who was the Veterans Treatment Court judge. And I mean, he had a major passion for soldiers who fought this country. However, they got themselves in legal trouble. Then they would say, let's bring them to Veterans Treatment Court. Let's get them help and treatment so they don't have to continue the cycle of violence that, or cycle of criminality, rather, that they may have been on. So, in conclusion, we had some key takeaways, right? We talked about the courts. We talked about what does it mean to, respect and understand the judiciary, recognizing that the judiciary are judges and they are the people who make up the core of the court system. Yes, you may have, we're going to talk about lawyers in the next chapter, but this was all about the star, which is the judge. That's why I kicked off this lecture saying, all rise, because you will command or you will respect judges. They command respect and they are owed and given respect. So I wanted to go over judges. I wanted to talk to you all about the Supreme Court. Understand it is very much politically charged, but hey, we'll see. And then lastly, I wanted to end off with problem-solving courts. What are problem-solving courts? What are the purposes? They ultimately have a rehabilitation approach. They're trying to treat the individual as sick. So they're trying to rehabilitate them as sick. And whether it's drug court, veterans treatment court, or there's any other court, the person has to want to be there and they have to want to make the change so they don't keep on that endless cycle of crime and criminality. So I want to thank you all for tuning in. Be sure to like and subscribe if you're not already doing so. Certainly share the word with other friends, other family members. And I hope that you found this first chapter on our module examining the courts as informative and as enlightening, because like I said, you may never go in front of a judge. You may never go into a courtroom. But if you do, I hope you can say, oh my goodness, I remember Professor Field's lecture from back in the day where he talked about you will command the respect. Yes, Your Honor. yes, sir, no, sir. It's not kissing butt. It's being respectful of the role of the judge, the role of the bench, and the role of the robe. So thank you so much for tuning in, and I will see you next time.